This is Tim Goodman, and with me is my colleague Rebecca Bernhard. Rebecca is an employment law attorney and will be talking along with me today about the gig is up. Our Q title is about the fact that these days more and more employers have people who are either being treated as independent contractors or perhaps as leased employees, and we're here to talk about the risks that are associated with that. To give folks a sense of some of the risks here, we're going to start with some of the tax risks. And on slide 4 of the materials here, we have a little example that we've entitled So Many Taxes, Penalties, and Risks, So Little Time. So let's just pretend that we've got a company and it's called Acme. And as you'll find out, you're glad you don't work at Acme because Acme has lots of problems. Due to the recession, Acme placed caps on headcounts and wanted to make sure it didn't get ahead of itself on the number of its employees. Managers who need someone hire through staffing firms in some areas like IT, just bring in independent contractors. To try and put this into perspective, we have the workforce composition as 200 full-time employees, 10 part-time employees, 30 leased employees, and 20 contractors. With that background in mind, the next slide gives a little example of what sort of tax penalties Acme might be facing if all or almost all those contractors are found to be misclassified and are actually employees. So for federal taxes and penalties on the misclassified contractors with respect to the employment taxes and income taxes, there's the risk of $128,000 in penalties. There's a little breakout there that breaks it down in terms of what those penalties would be based on, and later in the presentation we'll get into that a little bit more. There's also potential federal taxes and penalties for failure to withhold, and also there's the big one, the Affordable Care Act penalties. Keep in mind on that prior slide that this entity had 200 full-time employees and those 20 independent contractors were also full-time. When you look at that then, if they're excluded and they aren't offered coverage and they're truly employees, now that organization has failed to offer coverage to 95% of its full-time employees. What that means is that the organization is at risk of the ACA penalties, the big penalty, if even one of those 20 independent contractors goes out and gets coverage through the exchange and is subsidized. That penalty number is $615,000. To add on to this, there's also penalties for failing to properly provide W-2 forms and the Form 1095 under Section 6721, 22, and 24. That's another $15,000. And very quickly you can see we're up at about $750,000 in penalties just because an organization has about 10% of its workforce here in terms of being independent contractors when they're not. This doesn't count the other penalties and risks that they have, such as state taxes, benefit plan costs, and more. We'll cover all that, but when you're working with people, one thing Rebecca and I know is it's very hard to catch management's attention about this issue. It's hard to go in and say, we've got a lot of risk here. These slides here, these 2 slides are our attempt to try and help you when you're talking to leadership and other people and indicate to them why is it important that an organization really look at its workforce and who they're using. And we'll come back to that as we go through. But with that, I'm going to turn it over to Rebecca to talk about who is who.
Thanks, Tim. We think it's important to help folks understand who the players are in this scene. And it's important also to remember that legally there are really only 2 categories. You're either an employee or you're an independent contractor. We understand, as I'm sure you, that most people have different names for lots of folks. They might call their employees team members or associates, and they might call their independent contractors consultants or project managers. But from a legal perspective, and especially from the IRS perspective, the first category on the slide and the last category on the slide are the 2 that are at issue. And when the IRS does its analysis, they want to put someone into one of those 2 boxes. And as we'll talk about further, they like to put them in the top box, an employee. There are 2 other important categories that we'll talk about today as well, and that's the joint employee or co-employee arrangement, and then the leased employee. The joint employee and the leased employee overlap somewhat. The leased employee is an individual who works for a staffing firm and is sent to another entity to provide services. This is an important concept, especially in the benefits world, but that person is still considered an employee of the staffing firm with regard to most employment laws and with regard to tax laws. The joint employee may also be placed in an entity by a staffing firm, or it happens a lot in parent-subsidiary relationships in which a worker is performing work for two different entities. And for employment law purposes, the entities are both jointly and severally liable for any employment matters. With that, now that we know who's who, we can decide which tests we have to apply. Unfortunately, for those of you who are in-house, you have a lot of tests to worry about. This is good news for employment and benefits lawyers who are looking for business because it keeps us employed full-time trying to sort this out. There is the IRS test, which is the common law test. Many of us remember this as the 20-factor test, but the current approach from the IRS is to really analyze three major components of the individual entity relationship and to determine who is controlling most of the factors in each of those. Not one factor is determinative, and they take an overall analytical approach. The first category is behavior. What they're looking at is who is controlling how the worker performs the specific work for the company at issue. This is where questions like tools and work product come into play. The finances is the second area, and what they're looking at here is whether the worker has the capability by how they determine their work to realize a financial profit or loss. The final category is the relationship. The simplest way to think about this is whether the relationship is long-term and monogamous or whether that individual provides services to many different folks. The other test that's the other main test that we'll be talking about today is the Department of Labor's test, and that matters for the Fair Labor Standards Act and the FMLA, and that's the economic realities test. And that test looks at either two entities, if there are two entities in play, or the individual and the entity, and is asking whether or not there is a shared interest, whether there is an opportunity for the individual to make a profit or loss, whether one entity is controlling the other entity, to determine who actually has the economic control of the relationship. As I mentioned before, there are also other tests. The EEOC under Title VII and the ADA takes a look at a hybrid test. It's looking at the entity's right to control. It looks at a totality of the circumstances. Like the IRS test, it's looking at more than just the economic relationship, but it doesn't have the same specific factors that the IRS enumerates in its test. There are also state tests to be aware of. These come into play most importantly in the unemployment compensation and in the workers' compensation arena. And that matters because often these claims arise when an individual gets injured on the job or loses their job and goes to one of the two state agencies to try to retrieve benefits. So it's important to know what your state rules are as well. The practical effect of these tests is basically to consider who is exercising control over every aspect of an employment relationship. Who is determining who is hired? Who is determining who is let go? What kind of daily direction will be performed? All of those questions you should be asking yourself with regard to the individuals who are performing services. Although control is still the dominant factor, it's important to note that the National Labor Relations Act and the National Labor Relations Board is taking a broad look at the issue of control, and we will address that later in this presentation. The reason that Tim began with the penalties and what we're trying to emphasize is that much of the law that I just gave you an overview of hasn't actually changed, with the exception of the National Labor Relations Board's test. Hasn't changed in many, many years. But what has changed is that there is an increased focus on the DOL and the IRS. And so they are applying what is pretty much longstanding law to a new environment and trying to figure out how these new employees, this on-demand economy, fits into this old scheme. And it's a way in which they can determine how to properly classify folks in order to collect the revenue, who's collecting the taxes, who's making sure that the person is compensated properly.
And we're just going to maybe quickly go through two of these slides. You know, the DOL has really had a focus on independent contractors of late. They've been doing additional investigations, We have a slide here, and it's very small print. You could just go to the website at the bottom. But basically, from 2009 through 2015, there's been a 21% increase in the number of investigations that when the DOL does an agency-initiated investigation, in almost 80% of the cases, they find a problem. So those are not small numbers, and something, again, to take along with you if you're talking to management and trying to get them to realize things. Rebecca, real briefly on slide 13 here, do you want to just talk about this admin interpretation that the DOL issued?
Yes. So last summer, in 2015, the Department of Labor issued their memorandum regarding independent contractors, and it did get a lot of press. But as I said before, it really wasn't a new law. It was really a reminder that this is the law as we see it. And this quote here is just a reminder that it's not a checklist in which you can go and count the yeses and count the nos, and if you have the right number of one, you're safe. They really are looking at it on a balancing act, and the factors are really there because they really want to try to find an employee relationship.
And that's a nice segue to what I'll be talking a little bit about are the risks with the IRS. And one thing that's not on this slide 14 here is simply that one of the forms the IRS has is the form SS8. And just real briefly, a digression on that, that form is something that the IRS has on its website that you can look at and you could fill out to try and figure out if someone is an independent contractor or employee. But I highly recommend, again, sending that form in unless you're certain that you would like the IRS to find them as an employee. As Rebecca said, agencies, the DOL, IRS, et cetera, almost always are going to want to err on finding someone's an employee because for the government, that means then there's an employer and someone that they can follow up with if taxes aren't being collected or other things are not happening. If a person's an independent contractor, the IRS has to go back to that individual, whereas if there's an employer, there's someone for the IRS that is basically taking care of all these tax collection responsibilities. And so that's a form you might want to look at. It's a form when they come in on audit, they might ask you to complete on people you've given a 1099 to, but it's not a form necessarily that you want to submit unless you want to run a risk of finding that someone is not a contractor, but rather an employee. So on slide 14, just a note, just like the DOL, the IRS has really increased its audits on payroll tax. And there's a note here that they had 6,000 random audits in 2009 through 2012. That's one of the things that's changing is that increase. What we talk here about on slide 15 is some of those risks that were on slide 3. When we talked about the fact that there was the $128,000 in penalties, that stems from these rules. Basically, in essence, if someone has not withheld on wages, you have to keep in mind if an employer hasn't withheld, the timing of those wages going to the IRS is later, if ever, in terms of income taxes. And so they have a 1.5 to 3% of the wages that they will penalize you on. In addition, because self-employed individuals can claim deductions or take a share of their self-employment taxes, they look to recover 20 to 40% of the employee share of FICA, the employment taxes. And plus, the employer obviously hasn't paid its share of employment taxes, so they look to recover 100% of that. Higher rates can apply in certain circumstances, so it becomes the case that it's really a big penalty there. But the bigger penalty is really under the Affordable Care Act. And just to put this into perspective, slide 16 talks about the big penalties. I won't turn this into an Affordable Care Act presentation. Everything these days seems to, in some ways, touch on the Affordable Care Act. But the penalty, the big penalty is if you fail to offer minimum essential coverage to 95% of your employees, then you're looking at a penalty of $2,160 times all your full-time employees minus 30. That is a very big number for some organizations. The not as big penalty for every person who is not offered coverage but who is an employee and goes to the exchange and gets a subsidy is $3,240. So let's say in that Acme example, instead the organization had 1,000 employees and 20 independent contractors who were misclassified. They wouldn't trigger the big penalty, but they could still trigger that not as big penalty. If 10 of those contractors had gone to the exchange and got a subsidy, that's $32,000 in penalties, which is still not a small amount for many organizations. The penalties are assessed on a month-by-month basis, and those numbers I gave you are annual ones. But that also then needs to say, are there months when we have an influx of contractors or others where we might be more likely to be subject to those penalties? On slide 17, we talk a little bit more about this, and the point here to really note is about leased employees. And under the guidance, the Affordable Care Act regulations, basically, leased employees are likely, the IRS is likely to view them as employees of not only the staffing firm, but also the employer using them. Now, there's some language you can try and include in your staffing firm agreements to try and mitigate that potential risk, and there's not a lot of other guidance out there. But if you use leased employees, you probably want to review those staffing firm agreements and see if you are asking that the staffing firm provide minimum essential coverage that's affordable and meets minimum value to the leased employees who you're receiving from that staffing firm. If you have some language in that that is being required and that you're paying a higher fee, then you at least would have an argument that there should be credit given to you for those leased employees. One of the other things mentioned up on that slide 3 was failure to file penalties. So there's penalties that the IRS imposes when it doesn't get information, because the only way it knows when it needs to impose taxes is if it gets a W-2 or if it gets a 1095-C. If you fail to file those, it's a penalty of $250 for failing to provide one to the employee and the other to the IRS, so potentially $500. That amount can be smaller if a correction is made quickly or larger if there's intentional negligence. So those penalties are another type of penalty that can be imposed when you're not properly counting people as employees. So I'm going to turn it back to Rebecca here to talk a little bit about the FLSA damages and penalties. Rebecca?
Thanks, Tim. So I think that historically folks haven't thought about the risks under the Fair Labor Standards Act because so many consultants are professionals and tend to make a high enough wage that folks aren't thinking about minimum wage or overtime. The problem is that if you are treating somebody as an independent contractor, you may not be aware and you may not be accurately recording how much time this person is working. So you can't prove that they have been compensated for every hour that they have actually worked. So if you've got someone who's misclassified as an independent contractor, you can't show any records that they have been paid at least a minimum wage for every hour they worked if you turn out to have misclassified them. And that's where the big buckets of money come into play, because then we have some damages and penalties. You're always going to owe, just like taxes, you're always going to owe the unpaid wages or the unpaid overtime compensation. But on top of that, you can get liquidated damages, which can be up to 2 times what you owe. There are also civil penalties if the Department of Labor believes that you have willfully misclassified. There are punitive damages and attorney's fees available if litigation ensues and this is brought by individual or class action plaintiffs.
And Rebecca, I think as you can speak to, wage and hour class actions are one of the favorite types of class actions out there.
They are absolutely. They are a fee-shifting provision, and when you aren't paying somebody correctly, your chances are they're not alone in that group, and so they are a very attractive cause of action for plaintiffs' attorneys.
Yep. So back to me for a moment and to talk about employee benefit plan implications. And really, you can think about this as the Microsoft case as an example. If workers are employees, then they might be entitled to recover some costs for benefits which they would have been eligible for but for their misclassification. The background here, as most folks probably remember, is the Microsoft case. In Microsoft, it started out as an IRS tax audit, in essence, looking at people who were contractors and the IRS asserting they were really employees and Microsoft should have been withholding employment and income taxes. What happened in that case is after the Microsoft settled with the IRS, then the employees thought, well, the new employees, I should say, thought, well, if we're employees, we should have had benefits. And that led to further litigation and further costs for the organization, obviously. So since Microsoft, the IRS has approved this language that's now, for better or for worse, known as Microsoft language, that says if we misclassify you, you don't get to recover benefits back to when you should have been classified as an employee, only prospectively once you're properly reclassified. You will want to check your plans to see, do you have that language in your plans? If you don't, you have more exposure. If it's in there, that maybe cuts off some, but if you think about it, it's often found in retirement plans, but not necessarily in other plans like health plans or other plans like that. So that's one of the risks that you run. Another risk you run is with respect to Section 510 of ERISA. Section 510 basically, in a nutshell, says that an employer is prohibited from trying to prevent a person from obtaining benefits that they would otherwise have been entitled to. That's a very short reading of it, and people who know 510 would read it much better in a little longer time. But that is the basis of some litigation going on right now in the Southern District of New York in the Dave and Buster's litigation, where people were prevented from being able to be eligible for a health plan because their hours were reduced. You might have independent contractors, the plaintiff's attorney for them claim, well, they were classified as independent contractors to prevent them from attaining health benefits and lead to a 510 claim. Again, there's also potential civil penalties, and like the FLSA, the plaintiff's attorneys can recover attorney's fees. So ERISA is a very attractive status for plaintiff's attorneys as well.
So now that we've outlined the risks, we're going to take the rest of our time to try to help minimize or mitigate those risks. As I said earlier, with the exception of the National Labor Relations Board's decision last year, the law has not really changed. And although there are multiple tests across multiple laws and agencies, there is a common theme, and that is who has control. Who has control over the means and manner of performing the work at issue? Who has control over the individual worker's financial position? And who has control over the business relationship? And that's a two-way street to talk about and analyze, and you need to get a sense of that. And so on this next slide, we have some best practices with regard to how you should draft your contractor agreements. And we do recommend that you have agreements, but it's very important to note that it is not sufficient. A good contractor agreement will be helpful in an audit and will be helpful in litigation, but you will not win the litigation on the document yourself. However, you can lose on the document. And so you want to make sure that you don't have bad provisions either. It's very important to disclaim the employment relationship. We've seen agreements that people think they're independent contractors, and they actually say employment right in them. We want to make sure that we're not promising benefits. We want to make sure we're not withholding taxes. We want to make sure that it's clear that the contractor has the right to control. This is often where the in-house counsel and HR people fight with their business partners, because business partners want to maintain control even if it's with an outside contractor. But that's where you're going to fall down.
So real briefly here, some red flags, and we can summarize this in a nutshell in a sense, and that is the more a person is treated as an employee, the more likely it is that they are then going to be an employee if they're an independent contractor. So as Rebecca said, we've already talked about some of these, if they receive benefits, if they're doing a core business function, you know, if they come in and just fit seamlessly in and they're there for a great deal of time. If it's hard to tell one person is an employee from an independent contractor sitting next to them, they are more likely to be employees. I think we've joked that if they're coming to the company picnic, that's a bad sign that they shouldn't be viewed as an independent contractor. On the other hand, on slide 25, people who employers like in terms of classifying as contractors are people who are retained for special skills or unique value. You know, there's a story in the newspaper the other day that the Department of Defense is still using some computer systems from the 1980s and 8-inch floppy disks and stuff. And at that point, I guess that if you retain someone to help you with that, that person's an independent contractor. The number of people who are up to date on that are probably getting to be a dwindling number. If they've made a substantial investment in their business, do they have other clients? You know, if it's a business, you say, look, this John has got his own business card and business, that's great. But if you're his sole client, and you have been for the past 5 years, that calls into question, do they really have a business? Can they earn a profit or loss? And can they delegate their responsibilities? Those things make them more likely to be contractors. And Rebecca now is going to talk about co-employment risks.
So in addition to the difficulties in engaging with an individual, and those difficulties are across both the IRS and the Department of Labor, there are increased risks with regard to using staffing agencies, both with the FMLA as well as with the Fair Labor Standards Act, as well as the discrimination statutes. And as I mentioned earlier, the NLRB has taken a look at this relationship, and in a decision issued last August, the Browning-Ferris decision, has decided that companies need only assert indirect control, which is a difficult thing to get your mind around. And unfortunately, it's a very fact-intensive test, but it really does increase the exposure of employers who are using staffing agencies. While this is only the controlling law for the National Labor Relations Board with regard to union management relationships, it is a bellwether for the other agencies who are also trying to sort out what to do with the gig economy and what to do with all of these new on-demand and staffing agency distributor type of relationships. So in order to do that, we want to try to minimize the company control. There are going to be some industries which are heavily regulated, for example, the financial services industry or the healthcare industry, where anybody who walks on the premises has to be advised on managing PHI or PII, and so you're going to want to make sure you sort out that what areas you really have no flexibility with regard to control and what areas you do have flexibility with regard to control, and try to minimize the company control in the areas that are not externally imposed with regard to compliance requirements. That's going to take time with your business folks, but it's going to help you minimize that risk. You want to do your due diligence on these staffing agencies. You want to make sure that you're using financially sound staffing agencies who can actually address their own liability for the various employment laws. You want to make sure that you're looking at the agency's history and whether they have a history of litigation or union organizing, especially since that test is now the broadest test. You want to make sure that you're looking at who you're engaging with. And you want to have the ability to audit that agency's labor practices and their employment conditions. When you are contracting with the staffing agency, you want to make sure you have clear contract language and that the provider of the employees has good indemnification language, and that you clearly are identifying, who is the employer for which purposes. You want to be able to inform the workers that the agency is the employer. You want to confirm that the agency has adequate insurance coverage. You want to avoid the revolving door concept where someone is on the site for a couple months, or maybe they work up to 1,000 hours and then you send them away for a month and then you bring them back in, especially when that's happening in the same tax year. That's not really fooling anybody. And you want to be proactive. You want to make sure that if this is a need and this person has been around forever, you take a look at your staffing needs and wonder, why aren't they an employee of ours?
Yeah. And just real briefly, a few additional benefit aspects of leased employees to think about here. You know, leased employees, again, have been around forever, and what people tend to forget are there's some rules about leased employees with respect to benefit plans. You probably want to check your benefit plans to make sure they properly exclude leased employees. But even so, one thing you should be aware of is with respect to retirement plans, leased employees who are providing a lengthier period of service are included in testing, and that's often overlooked when people are performing testing. So if your organization uses a number of leased employees, you may want to go back and review, are we doing this properly when we're providing our third-party administrator or other people testing information? With that, we're just about out of time, but I think Rebecca and I would say again, you know, we understand this is a very hard thing to raise with other people in an organization. When we've talked to other clients again and again, we hear it's hard to raise. This is something we tackled 5 years ago, but it's come back. And it's because there's turnover in management. There's a little bit of, you know, changing economic conditions. And there are a lot of people out there that would like to have a gig instead of be an employee. But it's still very important. The law and the guidance that's out there is geared towards employers having employees. It's not geared to some sort of a gig economy yet. Maybe that'll change, but it hasn't changed yet. And so it's important to make sure that as you think about this, when you're trying to raise it with management, that's hard, but bring them some of this information. For example, the examples or some of the other risks. And hopefully then they'll be persuaded that it's worthwhile to do a review of your workforce so that you can avoid some of these penalties and taxes. Thank you so much for your time. We're going to turn it back to Liz.